Hello everyone. The concept of contract of indemnity as well as guarantee, which are defined under contract 2 paper. So contract of indemnity means the first concept contract which are already known in contract 1 paper, which means an agreement between two parties which are enforceable by law is called as contract. And indemnity means which is nothing but a compensation. The word compensation only arises as in the case of whatever the loss caused from one person to another person, that is a sum of money to paid as in the form of compensation is called as indemnity. So the contract of indemnity is defined under section 124 of the Indian Contract Act. So which means a contract by which one party promises to save the other from whatever the loss caused to him by the conduct of the promiser himself or any other person is called as contract of indemnity. So, contract of indemnity including the two persons or two parties, that is promiser or promisee, or indemnity holder or indemnifier. Indemnifier means a person promised to compensate the other party, and indemnity holder means a loss suffered by the other party. So the particular case laws as relating to this concept: New India Assurance Company Limited versus State Trading Corporation of India. Another case, Subhash versus National Insurance Company. In these two cases, to define what is indemnity. So judgment is likewise. Judge indemnity is not depends on the contract of indemnity or indemnity holder or any other person. Only indemnity arises from whatever the loss caused by the conduct of the particular events or accidents. Essential ingredients of the contract of indemnity. First one, there must be a particular loss, and there must be a loss caused by the promiser or any other person, and rights of the indemnity holder. So which is defined under section 125 Indian Contract Act. First one, right to recover damages. That is, right to recover damages, all the damages that he has or indemnity holder has compelled to pay in a suit in respect of any matter which the promise to indemnity applies that indemnity holder. And second one, right to recover costs. So all the costs that indemnity holder is compelled to pay in such suit, if any bringing on or defending it, he did not contravene the orders of the promiser and has acted as it would have been prevented that particular recovery of money. And next one, right to recover sums paid under compromise. And last one, right to sue for specific performance. So indemnity holder is entitled to sue for specific performance if he has incurred absolute liability as well as the contract covers such liability to promisee in a contract of indemnity. So acting within the scope of that authority. So he is entitled to recover from the promiser. So you already know what the specific performance means. It means equitable relief. That is, equitable relief is a court order action rather than the monetary award. So which is nothing but that particular specific relief is either party doesn't fulfill its obligations as per the terms and conditions of which is mentioned in the contract. So another concept, contract of guarantee. So which is defined under section 126 of the Indian Contract Act, which means it is a contract to perform the promise or discharge the liability of a third person in case of his default only. So the guarantee may be either oral or written. The particular parties which are involving in this contract of contract of guarantee, the three parties, that is principal debtor, creditor and surety. So these three persons which are also defined under section 126. Principal debtor is act as a third person or a third party. So principal debtor is a person in respect of whose default the guarantee is given called as a principal debtor, and creditor means the person to whom the guarantee is given is called as a creditor, and surety means the person who gives the guarantee is called as a surety. So the case law relating to this concept, contract of guarantee, that is Punjab National Bank versus Vikram Cotton Mills. In this case, court held that the liability of the both principal debtor as well as surety is just same the liability having both principal debtor and surety. So essential ingredients of this concept, contract of guarantee. So there must be a three parties, that is principal debtor, surety and creditor. And another one, guarantee need not to be in writing, or which is to be in oral or written, not will be particular form of written only.